Well, good morning, everyone, and thanks for joining us. We're going to do today's Ask a Pro webinar, which is titled The Subro Scoop, When Subrogation Touches Bankruptcy. I'll be one of the panelists today. My name is Ted Traut. I am one of the shareholders of the firm, and I'm the office managing attorney for the Cleveland office. I am also the Subrogation Practice Group Chair. I have practiced in the subrogation field for my entire career, which now is about a quarter of a century or so. So I hope we have some good information for you today. I will probably be more of the asker than the pro. I'm hoping Cam's more of a pro than me. But at this point, I'll turn it over to Cam to introduce himself.
Thank you, Ted. Good morning, everybody. My name is Cameron Deane. I'm the office managing attorney of the Philadelphia office here at Weltman. I'm also a member of the Subrogation Group and have been for a little over 3 years now, working with Ted and other attorneys here in the firm. In addition to that, I'm also a member of our bankruptcy department, representing creditors in bankruptcy matters. And prior to joining Weltman, I was at a debtors or consumer bankruptcy firm on the debtors side for a little over 10 years. So I have a lot of bankruptcy experience. And while I came here to do subrogation work, I just couldn't escape the bankruptcy court as best as I tried. So I still get a little bit of bankruptcy work out of me, and that's what we're here to talk about today. All right. Ted, we have a disclaimer we got to read through. Is that right?
Before we get started, just a little bit of housekeeping items. We want this to be an interactive session. If you have any questions, we'd like you to submit them through the chat in the toolbar there. Hopefully you can see where that's at. Questions we'll try to address during the presentation if we can. If not, we'll reach out to you afterwards with the answers. There's also going to be a short survey once we're done with the presentation and at the conclusion. We appreciate you taking the time, a couple of minutes to do the survey. The feedback's great. It lets us know what you're interested, what you liked, what you didn't like, and what you'd like to see in the future. So we'd really like to hear from you if you take the time to do that. But without any further interruptions, we'll go ahead and get started with the presentation. If you want to go to the next slide, Cam. Yeah, so I know for those of you who are fans of The Office, I certainly was. This is one of my favorite scenes is when Michael Scott's having some financial troubles and he steps out into the office and yells, "I declare bankruptcy!" And so they have to explain to Michael that it doesn't work that way. You can't just say I'm bankrupt. And he goes, "Well, I didn't just say it. I declared it." So I wish our format here allowed us to actually play the video. Because I'm sure Steve Carell's acting is better than mine, but wanted to give you a little flavor of that. So want to talk to you a little bit, as I mentioned earlier, full disclaimer, I am a subrogation attorney, and one of the benefits of being at a firm like Weltman, that's a big creditors' rights law firm, is we have a fully staffed bankruptcy department. So I don't have to be an expert in bankruptcy. I've got people like Cam that I can go to with questions. So while I know more than Michael Scott, I don't think I'm necessarily the pro's pro in this. So I know just enough about bankruptcy to probably be a little bit dangerous. So I will probably lay out some of the basic information and then at the beginning, and then as we go on, Cam will probably get into more of the weeds. But again, this slide's just telling you a little bit more of the ground rules. We should be here no more than an hour, and you'll get a link to the recorded webinar sent to your email after this. And again, the survey is helpful, as well as your ability to ask questions as we go along. So if we want to go ahead and start a little bit and talk about what we plan to accomplish today. So here's some of the basics. You'll learn what an automatic stay is, the differences between Chapter 7, 11, and 13, how to file a proof of claim, what that effect is with unliquidated claims like a subrogation claim, and what some of the exceptions to a discharge might be. So we'll talk about what an automatic stay is. So an automatic stay is when a petition is actually filed in a bankruptcy court. So I have practiced enough creditors' rights law too, where a lot of times we'll hear from a debtor in that situation, or it could be a tortfeasor in a subro case that says, "Hey, I plan on filing bankruptcy." Well, that's like being, you're either pregnant or you're not. You've either filed bankruptcy or you have not. So don't be fooled by someone's intention to file bankruptcy. The automatic stay does not apply until they've actually filed their petition and have a case number with the court. Again, sometimes they'll try to pass along their file number with their bankruptcy attorney. That is not a bankruptcy stay. So until the case is actually filed in the bankruptcy court, there is no stay. However, once it is filed with the court, it's a full stop. You cannot take any further collection or legal activity. You can't initiate lawsuits. You can't make phone calls. You can't send letters. If you've already taken a judgment, you must release any garnishments or bank attachments or anything that's pending. You should release a driver's license suspension at that point. The last thing you want to do is violate the automatic stay and be hauled into a bankruptcy court and be asked to show cause why you should not be found in contempt for violating the stay. And the stay does apply to any of the chapters that are filed. When a bankruptcy is filed, a bankruptcy estate will be established. This means that anything that is property of the debtor will be, you cannot act against anything. Everything is stayed. So, and we'll get into this a little bit more down the line, but insurance proceeds to a third party, like liability coverage, are not considered part of the bankruptcy estate typically, because the proceeds on a liability policy are actually owed to the injured party or the subrogated party, and the debtor, they're not part of their property. They don't have the exercise and control over it. So we'll talk about that a little bit further. But again, just to note that when you're talking about a bankruptcy estate, we're talking about the debtor's property, personal real estate, anything, cash, and things of that nature. So no, we're good, Cam. We can move on.
Okay. Sorry, jumping in there.
Oh, you're good. I was just babbling on like I do, like most attorneys. I like to hear myself talk. So then we'll talk a little bit, about what the different chapters are. So the big things to remember is chapters 7 and 13 apply to individuals. Chapters 11, typically, most of the time, is going to apply to a business or a corporation. So a chapter 7 is when you're seeking complete relief and a brand new start. So typically, in a chapter 7 no asset case, there will be a discharge and all your obligations to any creditors will be wiped away. Obviously, it's more detrimental to the consumer's credit when they have to file a no asset full discharge chapter 7. It takes them a lot longer to recover credit-wise, but it does give them a fresh start. Depending on where you're at, a debtor might file a motion to avoid their judgment lien if the judgment was obtained prior to the bankruptcy filing. Chapter 11 is, like we said, most likely going to be involving a corporation or a business. It's a reorganization of debt as opposed to a liquidation of debt in the chapter 7. Again, 11 and 13 are both reorganizations of debt. Chapter 13 is a reorganization of debt for individuals, and it's typically will result in the bankruptcy trustee taking a look at all of the assets and liabilities and coming up with a payment plan where a percentage of the debts will be paid over a 3 to 5 year basis. And typically in a chapter 13, any creditors will be required to file a proof of claim. And the amount of the recovery that you get will be based upon the debtor's assets, income, other factors of whether you have a secured debt or an unsecured debt, and there's various priorities that come through there.
Lost it.
We might have reached the end of my real bankruptcy knowledge. I might have some fake knowledge I can drop in from here on out, but I'll pass it over to Cameron at this point.
All right, well, and you fooled me, Ted. I gotta say, you really sound like an expert, being able to rattle off the basics there. So don't sell yourself short. But now just kind of getting into the weeds of it a little bit. And this is a question that I hear from both creditors, meaning our creditor clients, our carrier clients in subrogation. It's kind of thing that pops up all the time, especially when you're pursuing a claim. But It's always phrased as, well, I know that tortfeasor, I know that adverse party, they own real estate, or they own it's a 2022, Cadillac, they own a newer vehicle, something along those lines. So what an asset is in reality versus in the bankruptcy court is a little bit different. So just to give a basic idea of how we get to the point of, the no asset Chapter 7 case that Ted described, where they just get a complete fresh start, they walk away from all their debt obligations. This is a very basic overview of how that works. First and foremost, the debtor has to disclose all of their assets and their income in a bankruptcy petition that gets filed with the court, and that's what creates this whole process. On the creditor side, representing creditors, it's always my opinion that I have to take a very thorough approach and review of that bankruptcy petition, and I'm always checking it against other information that I have. So if I have any sort of background search reports or any information on the debtor from before they filed the bankruptcy, I check to see for any discrepancies, misreported income or lack of reported income, lack of assets being on the bankruptcy petition, things of that nature. And the reason why is because finding those types of missing pieces, that conduct on the debtor to conceal certain assets or income is something that can benefit you as the creditor and potentially exclude your claim from the discharge and let you get back to business as usual in pursuing recovery of your claim. So when those types of discoveries are actually made, the process can get pretty involved, and it is something that you pursue, which we'll talk about a little more later on in the presentation. But you pursue it in the bankruptcy case. But just keep in mind too, if you're subrogee pursuing it, if you're a creditor pursuing the claim here, you're not going to be the only person doing this review and this scrutiny of the bankruptcy petition. The bankruptcy trustee will do the exact same thing, and they hold kind of a mini deposition of the debtor called a meeting of creditors. That is an opportunity for the debtor to say under oath on the record that all of the information in their petition is true and accurate. So again, if we find something that is not true or not accurate, an asset that they fail to disclose down the line, that can really throw a wrench into their bankruptcy case and protect your rights as a creditor following the discharge.
Does that happen, Cam? Have you seen that where assets were found that weren't originally disclosed in the petition?
So I have, as I said before, I spent about 10 years on the debtor side. So unfortunately, it's much harder to be on the debtor side when that happens than it is on the creditor side. Just a quick example, I remember having one case where an individual, this is kind of when cryptocurrency became a thing. And an individual had some sort of crypto wallet with about $40,000 worth of cryptocurrency in it. Of course, he didn't tell me about that. I didn't know about it. And somehow the trustee, with all their vast resources, was able to determine that this guy had this crypto account. And we were just able to keep him out of criminal court. That's how close it was. He unfortunately did not get a discharge. He lost that $40,000 in cryptocurrency, but he didn't go to jail. So when you engage in that kind of conduct, staying out of jail is a win, I thought.
Yeah, that's a win.
Now, another thing too, as far as assets counting, which we'll get into more here, not all assets are assets, as I said before, in the eyes of the bankruptcy court, and that's primarily because of these exemptions. Exemptions of assets means that a debtor is able to keep, the clothes on their back, the house they're living in, depending on the circumstances, usually 1 or 2 motor vehicles. But basically the code, the bankruptcy code that is, it sets forth a variety of assets or property that a debtor can have and places limits on how much they're able to retain while still filing and discharging their debt in a bankruptcy. So this is something where it's really just, you need to review it on a case-by-case basis because every debtor's situation is different, and you review their exemptions claimed against their individual assets. Obviously, you got to make sure they're not claiming anything more than what the code provides, but that's part of the comprehensive review we do here at the bankruptcy department when we get a case, is really digging into the petition to make sure all the disclosures are accurate, first and foremost, but also comply with the bankruptcy code when it comes to the exemptions. Now, there's some exclusions for income too. These are for the most part the same in just about every state court I practice in. Ted, I would imagine you'd agree with that, but Social Security income is often excluded, meaning you can't attach it after you've got a judgment in state court. And the same deal applies here in bankruptcy court. It's just simply not counted as income for purposes of determining if this debtor should have to pay anything back. So even though they might be getting, $2,000, $2,500 or so in Social Security per month, might as well be a 0 on the paper because it doesn't count for this purpose. All right, so now that you have kind of a basic understanding of just what a bankruptcy is and some of the bigger questions I get from most creditor clients, really the next thing is to understand what to do once you've received that bankruptcy notice. So Ted touched on this earlier. Filing a proof of claim is the biggest and most frequent action taken by a creditor. It primarily occurs in Chapter 13 bankruptcy cases, also Chapter 11 bankruptcies, which are a little more rare for this type of practice. And then the one other big thing where they come up are in Chapter 7s. More often than not, your Chapter 7 debtor is filing a no asset case. So nobody's getting paid anything out of that. But every once in a while, there is an asset that gets either disclosed by the debtor or located by the trustee. And when that type of thing happens, you will receive a second notice in the mail from the bankruptcy court saying this case has been declared an asset case. And it'll set forth a deadline on how to file that proof of claim, which we'll continue to talk about throughout the presentation too. The other big thing you're going to do as a creditor is file for relief from the automatic stay. That is getting bankruptcy court's permission to continue with your state court action or your collection activity. A variety of reasons why you would do that, but as Ted said before, once you receive the notice of the filing and that stays in place, you got to do a full stop on everything you're doing. And if there is something you feel you're obligated to do, you got to talk with the bankruptcy lawyer about obtaining relief from that stay to pursue that action. And then the last thing we're going to cover, as it applies really to subrogation, is going to be claims that are accepted or excluded from the discharge that gets entered in the case. And this comes up in the context usually of motor vehicle accidents involving criminal conduct such as a DUI, other intentional torts, which I don't really see too much in property damage subrogation, but things pop up all the time. So it's always just good to be cognizant of what your rights are as a creditor when that situation arises. So before diving into the weeds of filing a proof of claim, I do see we have a question here that popped up, and it's whether a creditor needs a judgment in order to file a proof of claim. So the short answer is no, you don't need a judgment, but if you're a subrogation creditor, a judgment is certainly going to help. And you can see on this slide here, I have secured versus unsecured, and that's exactly the answer to this question. If you have a judgment lien against your adverse party, that will secure your claim in the eyes of the bankruptcy court because that lien attaches to the property owned by the debtor, regardless of the exemptions, really. Now, you might have a lien avoidance action down the road filed by the debtor, which we'll address, but ultimately, you don't have to have a judgment to file a claim, but you have to have a judgment to file a secured claim, which would be the preference if you can do it. Now, if there's a difference between having a judgment or not, does it have an effect? Yeah, just as I said, having no judgment would mean you're filing an unsecured proof of claim, and potentially, depending on the nature of your subrogation action, it could be an unliquidated claim, which can create some havoc for you as a subrogation pursuer or party, because then you get into the weeds of if you have to go back to state court versus pursuing your claim in bankruptcy court, which we'll touch on as it does come up occasionally in practice. So as I said before,
I understand, Cameron.
Yeah.
So I'm learning here too today. So there is sort of a priority when the court's determining which claims are going to get paid out. And so
Correct.
That's why it matters whether it's secured versus unsecured, because the secured has higher priority than an unsecured claim. And that's why having a judgment is better than not having a judgment, correct?
Yep, that is exactly it. You hit the nail on the head. And the list of priorities, it goes well beyond just secured and unsecured, but far beyond the scope of what we need to cover today. But the three main varieties are priority claims, secured claims, and unsecured claims in that order. You as a subrogation creditor are probably not going to have a priority claim. That's usually reserved for taxes or child support obligations, things of that nature. But secured claims, they have the second best chance of getting paid in full. So if, like Ted's example from the beginning, if you have a debtor saying, I intend to file bankruptcy, if you are potentially days away from getting your judgment entered against that debtor, you want to get that done as soon as possible before that bankruptcy gets filed to get that secured claim status. Now, the other big important thing to remember when dealing with proof of claims in any type of bankruptcy chapter is the deadlines. The deadline will be on the notice you receive from the court advising you of either an asset in a Chapter 7 or just the notice of filing in a Chapter 13. But it's very important to follow those deadlines because there's very few exceptions to getting beyond that deadline, meaning the court oftentimes does not grant an extension of it or does not grant a party leave to file a claim after that deadline is passed. It has a pretty strong requirement of showing lack of notice and almost intentional lack of notice on the part of the debtor, you might say. So best thing to do is just get the claim filed, and that is the simplest action to take in a bankruptcy. And that's, I think, part of the court's reasoning here is it's so easy to get a proof of claim filed. We give you 75 days to do it. There's no reason you should have missed the deadline. So keep that in mind. Now, the next most common action a creditor is going to be taking is filing a motion for relief from the automatic stay. So Ted pointed out that the biggest example I see in subrogation, and Ted pointed out, is insurance proceeds, liability coverage. That's not property of the bankruptcy estate. And technically speaking, that means the automatic stay doesn't apply to that. But in the world of subrogation, oftentimes the only way you can get the liability coverage to come into play to get the carrier to actually issue a payment is to sue their insured, the adverse party, in state court to prove negligence or to prove fault and obtain a judgment. Unfortunately, because of the automatic stay, you can't just go sue that adverse party, even if you are only looking to recover their insurance proceeds. First, you have to file this motion for relief from the automatic stay. You have to have cause to do so. And oftentimes, cause can be proven by saying this debtor is the subject of a motor vehicle accident. We are pursuing the debtor in state court. We have no intention of pursuing any amount beyond the policy limits. That's perfectly fine to say. And so you're seeking a limited order of relief just to basically let that debtor's name be the caption, be your defendant in a state court action, eventually proceed to trial, proceed to judgment, and then deal with the insurance company thereafter. That's, again, an important thing to remember here is at the end of the day, more likely than not, the debtor is not going to have a personal obligation to you for your subrogation claim. So if they do obtain a discharge in their bankruptcy, even if you obtained relief from the automatic stay and obtained a judgment against them, odds are your judgment's limited to whatever the insurance coverage proceeds are.
And so that motion, just so refresh my memory, Cam, that gets filed in the bankruptcy court then?
Correct. Yep. So that is a motion filed in the bankruptcy court. And something I wanted to make a note of here, because I know with subrogation, this kind of changes from jurisdiction to jurisdiction, how the plaintiff is named. But the motion must be filed by the real party in interest. And that's actually really important because if an order is entered granting relief from the stay, so a debtor can be pursued, it only applies to the party that filed the motion. So, a common example you might see in subrogation is the insured might have their own claim against this same defendant, the same adverse party. Their attorney might have filed for relief so they can pursue that claim in state court and have access to the defendant's or the debtor's insurance coverage. But that order only applies to that party. So if there's a separate property damage claim that the insurance carrier is now pursuing against that same defendant, that insurance carrier has to separately seek relief from the automatic stay by filing this motion in bankruptcy court, and they can't just piggyback off of their own insured separate relief order, if that makes sense. So just something to keep in mind that you as the subrogee, the insurance carrier, always have to obtain your own order for relief if you want to pursue the state court action. Now, when you file this motion, like any motion filed in court, there's an opportunity for the other side to object, to respond, or to have to force a trial or a hearing on the motion. That in practice, as on the subrogation side, the only reasons I see these objections are they just want the orders to limit any proceeds you might be entitled to the insurance coverage. Now, if we're talking about an excludable type of debt, a DUI, for example, you're going to have to push back and have a separate fight, and that's where you're going to have a more involved motion practice in the bankruptcy court. But more often than not, I don't see much pushback. Debtors counsel are always willing to just sign a stipulation granting relief if you're limiting it to insurance proceeds, and the trustee does the same thing. But again, they do have an opportunity, so you just have to be aware that it could be a contested motion. All right, now this is one of the more complex areas of bankruptcy, not just as it relates to subrogation, but on the creditor's right side, it's pretty much top of mind focus for every creditor who's dealing with the now bankrupt debtor. There's a variety of things that can accept your debt from discharge, as well as exclude a discharge from being entered altogether for the debtor. So we kind of covered the conduct earlier, lying about a $40,000 cryptocurrency account, that's going to be a problem. That will prevent you from getting a discharge in your bankruptcy case if you're a debtor. But as it relates to specific claims, the one we see most often in subrogation are DUI claims. As you can see on the slide, there's just a few examples. Well, that's actually text from the bankruptcy code, but it's a good example of what the most common excludable debts are. The one on the bottom there, any sort of death or personal injury caused by the debtor's operation of a motor vehicle while intoxicated using alcohol, drugs, or another substance. And the code section actually expands beyond that. It could be any type of damage, so property damage would be applicable there as well. And Ted, I'm sure you do the same thing. I know in my subrogation practice, if I ever see a police report that has any sort of mention of a DUI or any other sort of criminal conduct, first thing I do is go check public criminal dockets, and I find a record of that conviction, and that goes right into my file. Not only does it help me in state court proving liability, but it's also always going to be there. So if that defendant ever happens to find themselves in bankruptcy court, first thing I'm going to do is pull out that criminal conviction, show it to the bankruptcy judge, and say, this is a claim that is not going to be discharged in this bankruptcy, and here's why. Here's the criminal conviction. So, okay.
And I would say, so one of the other ways I've seen this come into play is, we don't get a lot of intentional torts, but occasionally you'll have like a road rage incident or something like that, where someone will, either purposely ram a vehicle or get out of their vehicle and injure somebody intentionally, and it gets paid under their, their med pay or their UMBI coverage. So they do happen. They're not that often, but the DUI is certainly the most common thing. But I just want to add that.
Oh yeah, for sure. And I think, when we were prepping for this, I think I mentioned to you, I had a case once where it was an individual who just fired several rounds out of a firearm into the insured vehicle. Luckily, nobody got hurt, but of course, there's a criminal conviction for firearms offenses. So that's the first thing I did in that case, is add that criminal conviction to my file and have it in the back if we ever need it, should we ever find ourselves in bankruptcy court for that claim. All right, now actually excluding your debt from the discharge in a bankruptcy case is a more involved process. While I like to imagine I could just walk into bankruptcy court and show a record of a criminal conviction, unfortunately, there's a little bit more to it than that. But at the end of the day, it's not that different than just proceeding with like a typical federal lawsuit. However, the main exception is you're always doing this in bankruptcy court. So you're not going to your typical federal district court where you might file your federal tort claims, and it's obviously not something you pursue in state court either. It's in that same bankruptcy case, you are then filing an associated case that bankruptcy court calls an adversarial proceeding. It's handled the same way. You file a complaint against the debtor, naming them as a defendant. You outline the conduct. Your typical federal rules of civil procedure and pleading requirements would apply there. But ultimately, you just have to prove facts such as the code provides for here. You have to prove out these facts in order to have the court find your debt is something that should be excluded from discharge. So at the end of the day, this is something that needs to be viewed at like any other court proceeding, meaning it could become contested. You could have a trial on this, and so you need to plan for that from the outset. Oftentimes, winning a non-dischargeability action is the same as winning a judgment in state court. Does not mean anything about you actually making a recovery. Doesn't mean you're getting paid. It just means that this debt's not going anywhere. And it means that this defendant's going to have to deal with this for however long they take to get it paid. But unfortunately, obviously, no check is coming from the bankruptcy court once you get this action done. So keep that in mind too, but depending on the type of claim you're dealing with and what the balances are, the collectability from the defendant. One thing I always remind clients when they want to pursue an adversary proceeding is whatever the reason is, they always say, well, we may not collect anything. I mean, this person qualified for a no asset Chapter 7 case. And I always have to remind them they did, but keep in mind, they just got rid of, however many tens of thousands of dollars in other debt that they no longer have an obligation to pay. You're going to be the only game in town after this bankruptcy is done. So it might still be a slog, it might still be a long process of collecting, but you are the only outstanding debt obligation that person is likely to be dealing with when we're all said and done here. So just something to keep in mind, whether or not you're deciding it's worth pursuing this type of action. All right, so again, we kind of covered this. One thing to note though, and this goes back to the question from the audience earlier about a secured versus unsecured claim or a judgment being entered or not. One of the main issues that comes up on both sides, whether you're representing the debtor or a creditor in a bankruptcy case, is the bankruptcy court is one of limited jurisdiction, they call it. So that means that the bankruptcy court can only rule on issues that are core proceedings found within the bankruptcy code. And the main reason why that's important to understand if you're a subrogation professional is if you are in the early stages of pursuing your claim, and the big example is like an uninsured motorist subrogation claim where damages are not specific. I mean, from your perspective, the insurance carrier, they are. You settle with your insured, you have a specific sum that you're seeking from the adverse party, but the basis of the damages, depending on the jurisdiction you're in, are often uncertain because they're related to pain and suffering, bodily injury, things of that nature. So when you're dealing with that type of claim, the bankruptcy court will often view that as an unliquidated claim, meaning it's an unspecific amount of money that can really be determined. And a court has to make a determination based on the facts, based on the medical evidence of how much that claim is actually worth. So when you get to that point and a bankruptcy court has decided that this is an unliquidated claim, their next step is more often than not to say it's an unliquidated claim for injuries and therefore it is not a core proceeding because it doesn't have anything to do with a determination of assets, a determination of dischargeability. Even if dischargeability is at issue, the court will still basically decide that one narrow point and then kick you out and send you back to state court for a state court judge or jury to determine what your actual damages are. So that's something to keep in mind too. And another reason why you should be keeping your claims moving along because this risk of a adverse party filing a bankruptcy is always there. Once you've obtained a judgment, that determination's been made, your claim has been liquidated. You no longer have to worry about this bankruptcy court versus state court fight that can come up in these types of cases. So something to keep in mind. Again, it's because it's really the nature of tort claims, they're almost never going to be considered core proceedings in the eyes of a bankruptcy judge. And so if you're pre-judgment on your claim and it's not a specific sum that can be calculated like a property damage claim can, there's a good chance that by pursuing this adversarial proceeding, a bankruptcy judge is, they might rule in your favor on the dischargeability issue, but they're probably still going to kick you out and make you go back to state court to determine what the actual damages you're entitled to are. So something to keep in mind there. All right, now just generally speaking, you as a subrogation professional, I think you just got a great overview of all the basics of a bankruptcy process and really the important things to understand if you're on the creditor side of things, receiving a notice. So the big takeaways really as it relates to subrogation are how they are affecting an insured claim. So keep in mind, you can always continue to pursue your other insurance carrier, your adverse carrier. If you have to file a lawsuit though, naming their insured as a defendant, you have to pursue relief from the automatic stay in the debtor's bankruptcy before you begin that action. Now, actually, one question I had on that point from a client was the opposing carrier is a member of ARB forums. So we want to pursue an ARB forums claim. Do I have to obtain relief from the automatic stay to do that? And the answer was no, because the insured was not really a named party. I mean, they might be called upon for evidence. They might be called upon for a statement from their insurance company for purposes of submitting evidence to the ARB forums claim. But because they're not a named defendant in an actual court action, it wasn't necessary to obtain relief from the automatic stay. And the big thing, to keep in mind there too, is if you're pursuing a claim in ARB forums, there's obviously sufficient limits on the other side to pay the claim. So there's no risk of any bankruptcy estate property, i.e. debtor's property, being at risk when you're pursuing an ARB forum claim. So that's one big exception, again, just because the insured is not named individually as a party in any sort of court action there. But if for any reason you were naming them, then you would have a separate conversation with the bankruptcy attorney, more likely than not, about obtaining relief first. Now, with the uninsured claims, which unfortunately do occur, this is something we covered. If you have a judgment against a debtor who did not have insurance, they might still have an asset, even if it's just a little bit of equity in a vehicle. That's an asset that lien attaches to. So you can file your claim as a secured claim. As Ted pointed out, obtain that higher priority. And so if there is potential payment coming from the bankruptcy case, the odds of you getting paid, a decent portion are much higher with a secured claim versus an unsecured claim. And, lastly, as it relates to subrogation professionals, DUIs are the big thing to keep an eye out for. It's important to keep an eye on those criminal cases, keep an eye on convictions, because not only do they help you basically make proving liability, no question, super easy process in state court for your subrogation claim, it also protects your claim from potential discharge should that individual ever find themselves in bankruptcy court later on. Let's see, so I am getting a little bit ahead of myself here. I guess I don't see any other questions, but if people do have questions, feel free to put those into the chat, and we will address any that pop up here. Ted, I guess, was there anything I might have been missing?
No, we're going to talk about how the statute of limitations gets affected during a bankruptcy claim. Yeah, so.
Well, correct. Yeah, we do have more here. Okay. Yeah, so that's a big one and a wonky one too. So the statute of limitations are obviously a top of mind issue for people practicing subrogation. And the really important thing to know when a bankruptcy is filed, and it only matters if you haven't filed your state court case yet. You haven't initiated your action against the defendant, but you're getting close to that statute of limitations date. If the debtor files a bankruptcy, which prevents you from then initiating that state court action, obviously there's going to be an exception to the statute of limitations defense when you are ultimately able to file it. But the way it works, or the way it's calculated, is something that I see bankruptcy lawyers on both sides miscalculate all the time. And the rule, I think, is simple the way I lay it out, but more or less, if the statute of limitations would have expired while the debtor is in an active bankruptcy case, it's still expired. That's where you need to start your analysis. But what the exception is once you receive notice that that bankruptcy stay has been terminated, and the actionable events there are the case has been discharged. A lot of times Chapter 13 bankruptcies get dismissed without a discharge ever being entered. So as soon as that discharge order, or that dismissal order rather, is entered, the stay is terminated there. Or if you filed a motion for relief to terminate the stay, if before those orders that terminate the stay are entered, your statute of limitations expired, then you have 30 days from the date that order is entered terminating the stay to pursue your claim. That's the way the rule is laid out. It's section 108, I believe, of the Bankruptcy Code. So it's not a complete tolling of the statute of limitations, which is something a lot of people think it is. These Chapter 13 bankruptcies, for example, they're open for 3 to 5 years. So that is oftentimes more than all the applicable statute of limitations that you're going to be dealing with, depending on your jurisdiction. And if the statute expires and you receive that dismissal notice, that is your trigger. You have to know to file the bankruptcy, or not the bankruptcy, you have to file your state court action right away. Now, Ted, I don't know about you, but one of the main reasons why I really like working at Weltman with both the Subrogation Group and the Bankruptcy Department all under one roof is because more often than not, when I have a claim that gets put into bankruptcy, I take it to the Bankruptcy Department, which is also my desk. But that means I also am monitoring the bankruptcy, and I'm getting a notice as soon as that order terminating the stay is entered. I know that my 30-day clock is running on that claim. Whereas, somebody who might use external vendors or multiple vendors for the service, they're waiting to hear about the termination of the stay from one and then get the file over to another. And 30 days can go pretty quickly when you're working with multiple people to enforce your claims. So one of the big benefits we have here is that we're all under one roof, and we can get a file moved from one department to another right away in order to get that 30-day deadline complied with.
Correct.
All right, now this is another big one. Only on the creditor side do you see this be an issue, but it's preference payments. Preference payments are one of the issues in bankruptcy that prevent a fair proceeding. You know, when Ted said at the beginning, the purpose of it is to give the debtor this fresh start. That fresh start is granted so long as it's fair to all creditors. And it may not sound like it, but all creditors receiving $0 is technically fair to all creditors. Because if the debtor circumstances provide for it, that's fine. What's not fair is if a creditor is singled out or chosen by the debtor to receive, you know, something. You know, maybe the debtor has $10,000 in their bank account. They know they got to file a bankruptcy, and they've been working with this one bank since they turned 18, and they know the manager there, so they decide to pay off a credit card with that bank in the amount of $10,000. Now they have no money, and they go file a bankruptcy and try to get rid of everything else. What happens is the bankruptcy trustee basically doesn't like that. They say, why should this one creditor get $10,000 and everybody else gets nothing? And what they're going to do is they're going to claw back that $10,000 payment, basically file a lawsuit against that creditor to recover the money, and then evenly distribute it to all creditors to again get to that fair distribution. Now, as it relates to a subrogation claim, more often than not, what I see is people will have a judgment obtained against them. We will have already undertaken post-judgment enforcement actions, such as a driver's license suspension or something like that. And when a person, you know, sets up a payment plan to get their license suspension release, those payments will be made for, you know, several months. At some point, that debtor just decides they can't handle it anymore and they file a bankruptcy. Then the unfortunate scenario happens where my next notice is I get a notice from the trustee saying the debtor disclosed payments of a few $1,000s to you or your client, all in the 90 days preceding their bankruptcy filing. Basically, prove to me why it's not a preference payment. And the bankruptcy code gets into a lot of exceptions to preference payments. But at the end of the day, it's something where when it happens, you really need an experienced bankruptcy attorney to both respond to the trustee notice regarding the clawback and preference payments, but also, you know, understand the bankruptcy code, because not every payment is a preference payment. And you have to, going back to the comprehensive approach we take within the bankruptcy department here, you have to review bank statements, you have to review financial documents of the debtor, because you're just one of many creditors, and it's not a preference if everybody was getting paid something, you know, at the end of the day. So that's why you have to just really dig in the weeds when this type of action gets pursued by the trustee. It's not a good day when you get the notice in the mail, but it doesn't mean you have to give all that money back, at least not right away. It's just a process of analysis and then negotiation more often than not with the trustee.
Cam, typically, is there a threshold? I know there's a 90-day time period, but is there a dollar amount? For some reason, I seem to recall maybe like $600 or something.
Yes,
being a
it is. Amount. Yeah, so it's an aggregate amount within that 90-day period. It is, now it's escaping me. It's either $500 or $600 now, but for some reason I can't recall exactly what the figure is. But yes, so that's something to keep in mind too. Is you know, unfortunately, sometimes people can't afford more than, you know, $50 a month, and if that's all they're paying for 90 days, you don't have to worry about a preference payment there. But you know, the other exceptions are, you know, large lump sum payments are usually where you see this pop up, or obviously anything in the aggregate over a certain amount. But you know, keep in mind too, the trustee is they are an appointed official. They're supposed to not really have any skin in the game. Their goal is to, more than anything else, find an asset here. That preference payment is something that would be considered an asset, so that's why they pursue it. But at the end of the day, if we're talking about a pretty limited asset, you know, they're no different than any other party pursuing a lawsuit. You know, they're only going to spend so much of their own time and resources pursuing a claim. And if there's just not much of a claim there to pursue, they may not pursue it at all. So while that aggregate threshold is pretty low at $500 or $600, you know, even at $1,000, the trustee has to make their own decision of, do I want to spend the time and resources to pursue this $1,000 preference payment, or am I just going to let it go? So keep that in mind too. Even though you get an initial demand letter, everything's negotiable at the end of the day. So always got to just have somebody being responsive to it, though. You cannot ignore these things. All right. Well, again, we certainly have a little bit of additional time if anybody has any questions, whether it's subrogation or bankruptcy generally. I know we had some questions pop in originally too, in advance. See if I can find those.
Yeah. Your Outlook, there you go.
Yep.
I'll move that to the.
Need to have more control over my screens here.
Yeah. We do have a question. If a debtor files for Chapter 13 after you repossess collateral, do you have to give it back?
All right. Yeah, sure. So that's not really a directly subrogation related question. I'm assuming unless an insurance carrier is repossessing assets, but it is something that comes up a lot. There's an old rule and a new rule. My clients all operate under the new rule now, which is no. There was a Supreme Court case, gosh, has to be maybe 6 or 7 years ago now, that said the automatic stay just requires creditors to maintain the status quo, meaning no more affirmative steps one way or the other. So if you've already repossessed a vehicle and the day after that repo occurs, the debtor files a bankruptcy, you have no duty to return the vehicle, but you also cannot dispose of the vehicle or sell the vehicle. Now, the reality is the debtor can just file what's called a motion to turn over property, meaning they're going to say that at least some equity in that vehicle is property of the bankruptcy estate. I need the vehicle to get to and from work in order to make payments to the bankruptcy estate. Some reason why they need the car, and I've never seen a bankruptcy judge deny that motion. So the reality is, while you don't have to return it right away, debtor will file a motion for turnover, and 9 times out of 10, a bankruptcy court is going to grant that motion, even if you oppose it as a creditor. So there's not really much point in fighting it. And to save my clients money, I just say, hey, you can either pay me to defend this and you're going to lose, or you can just turn the vehicle over voluntarily and call me if they ever stop making payments, and we'll get it back. That's the approach I tend to take. But, the actual answer is no, you don't have to give it back right away until a court orders you to.
Okay, I'm not seeing anything else coming through the chat. Do you want to close up here?
Yeah, sure. So I was checking to see if we had any other questions, and we do not. But all right, well, just kind of a little closing script here, guys. Thank you again to everybody for attending today's Weltman webinar. We hope you found the presentation informative. As a reminder, as Ted mentioned in the beginning, a short survey will pop up on your screen when this webinar concludes. We do ask that you share your feedback and let us know what future webinar topics you would like us to present on, as well as what you liked and didn't like about this. We do read through those surveys, and we really want to make sure we're putting out the best content possible for our clients and potential clients. I would also like to share that we have a complimentary library of webinars, over 40 webinars now that you and your team can view on demand. Our collections offer information on a variety of topics such as collateral recovery, just to point out the question we just had, that's something we cover extensively. Real estate default, bankruptcy, just to name a few. We'll send you a link to our library so you can access all of those webinars, as well as a replay of this webinar. That'll be coming in a follow-up email to come again after this concludes. But thank you again to everybody for attending, and really hope you enjoy the rest of your day.
Thanks, everybody.